I'm crashing the fuck out because tell me why are the Dodgers going to the White House? Take this fucking shit off. Take this fucking shit off. I fucking can't. Benny, give me that fucking shirt. Give me your fucking shirt. Fuck Otani. Fuck Freeman. Fuck Mookie. Fuck Kike. Fuck Banda. I don't give a fuck. I'm fucking losing it, bro. I'm fucking losing it. Count your fucking days. Dodgers, count your fucking days. Ah! I can't fucking breathe. I'm fucking shaking. Shut up. Shut up. Get. I don't fucking care who is in charge. I don't fucking care what is the fucking tradition. I don't fucking care. It's all fucking stupid and I fucking hate you guys. Count your fucking days, Dodgers. Count your fucking days.
This is hilarious. Psycho much? The leftist Latinx Latinos are going nuts because the Dodgers went to the White House and had a great time with President Trump. Why are you so mad? Don't you know that Latinos helped Trump get in the office? We support Trump and the Dodgers. Just shows this is hilarious.
Well, alrighty then. Good evening, everybody. Welcome to the following program. I'm your host, Joe Newman, a.k.a. Good Logic Sans Spectacles. That's right. That's right. Yes. Yes. Let's try something new. Let's try something new. We're not going to be like flying blind here. It's not a joke. It's not even a joke. It's really when I used to play poker back in the day when I had a social life of some sort. So I used to play poker and they would make fun of the fact that like they had to sort of like shove the cards, the flop like cards toward me. Like, can you see that now, Joey? Can you see it now? Almost. Wait, is that a club or a spade? I don't care. Yeah. Anyhow. So I can relate. I can't relate to that woman who is freaking out and ripping her jersey, just saying, done. I had a roommate back in the day when I had roommates who I wasn't married to. So I had a roommate who was a diehard Knicks fan. Oh my God. When the Knicks would lose, he would just take his Knicks jersey and he's like, "You're losers. You can't hit a free throw. If the game's on the line, you can't have a free throw." And he'd be like trying to rip up his jersey. He one time set it on fire. I was always, as a youth, I was pretty passionate about sports, but I never got to a place where I actually considered vandalizing my own property or anyone else's for that matter. Not even for like, it never even was like a fleeting thought, but he'd be like, "Losers, you stink. Now that's frustration with Charles Oakley inability to hit a free throw. Xavier McDaniels or Patrick Ewing's inability to hit a free throw, or Lord help us, sometimes John Starks. But yes, I understand that to some degree, getting that outraged over the fact that the world champion Dodgers went to visit the White House is just like, whew. Okay. People are saying stuff and more stuff. There's more stuff. I see something Zenny Optical, get a cheap backup pair of glasses. Yeah, I'm supposed to be actually later this month. I actually have an appointment with an optician. So I figure that will enable me to get an update on my prescription. Because when I first got this prescription, so I hadn't gotten glasses in years, like probably a decade. And the optician I went to was like, if I give you what you really need, you're going to get headaches. So I need to like sort of grade you in there. grade you in. And that's what I've been using ever since for like the last year or two. So that's probably going to be more superfied, where I'm going to be like X-ray vision. I'm going to be able to like basically stare into the camera and shoot laser beams out of my pupils. It's going to be crazy. It's going to be crazy. You're going to love it. You're going to love it. Never, only for good. Only use my powers for good. But that's coming. Well, it's supposed to be near the end of the month when I have that optician. So it'll probably be sometime in May before I actually get the glasses. But that's my new pair. In between, at some point, I'm sure I'm going to find them. Anyhow, let's get on into it. Because I want to talk with you all about the Karen Read and her application to the Supreme Court. She has an application, a petition for writ of certiorari, that she claims that she cannot be tried on anything that the jury has already decided, and even if there was a mistrial, that doesn't now reawaken or give the prosecution a new opportunity to prosecute her for whatever charges it is that they reach a determination on. And the lawyers call it an issue of first impression that almost came before the court, but the Supreme Court decided its way out of it in a different case where they end up not having to address this issue. So they're asking the courts to address it now, claiming it's an issue of first impression. It's a really interesting claim that they're making. And I'm curious about your thoughts on it. I'll give you my thoughts as I'm going through it as to how good it is, how good it reads to me at least. But let's break it down now here for you good folks, because that's what we got to do. That's what we should be doing. Without further ado. So what have we here? Is this what I wanted? I think this is the right one. No, this is the right one. Oh God, it's almost like you're teasing me. It's almost like you're teasing me. Unleash American Energy. That's my version of UAE. Love you, Joe. What may be a cult leader, totally not a cult leader. God bless you, Gene Dean. Thank you for the 20. I appreciate that. Thank you. Attach said cheap pair to the computer desk like bank pens on those chains. Never lose them again. That's an interesting idea. I like your thinking there, Elephant. I like your thinking. All right. On petition for writ of certiorari to the United States Court of Appeals for the First Circuit. This is the petition for writ of certiorari. Questions presented. Oh, Lord, this is really bad. This is not good. I gotta make this a little bigger. A little bigger. Oh, Lord. I lost you. Whether a final and unanimous but unannounced decision by a jury following trial that the prosecution failed to prove a defendant guilty of a charged offense constitutes an acquittal, precluding retrial under the Double Jeopardy clause. So, in case you don't know the term Double Jeopardy, it's constitutional device which says that once jeopardy attaches, you cannot be charged a second time for the same crime. So, the question here is, at what point do we say jeopardy attaches? Once jeopardy attaches, so in that case, the claim being, you couldn't prove me guilty on your first bite at the apple. Why should you have a second bite at the apple? But Karen Read, we have mistrials all the time. This is obviously not the first time we ever had a mistrial, but Karen Read believes that she has a stronger basis for an acquittal based on this mistrial than in most mistrials that we've seen in the past. Question 2 is whether a defendant who produces credible evidence of such a final, unanimous, and unannounced acquittal is entitled to a post-trial hearing to substantiate the fact of such acquittal. So what is she saying here? What makes this case different than any other mistrial, which there have been countless mistrials of criminal cases in American history? None of them resulted in a successful claim of double jeopardy. Prosecutors go through all the time. They bring their case, they can't get the conviction, they turn around and they say, all right, let's go for another jury. They couldn't reach a decision. What they're saying here is they're claiming that there was an unannounced unanimous decision on two out of the three charges brought against her. So brought against Karen Reed 3 charges. There's one for trying to leave the scene of a crime, another for murder 2, which is intentional homicide, another, I think, for vehicular manslaughter, meaning it wasn't intentional murder, but that she accidentally killed O'Keefe. Now, there's the jury. She's claiming that the jury unanimously agreed that she didn't flee the scene of a crime and that it wasn't murder 2. But they never announced it, nor did they actually have an opportunity to announce it because of the conduct of the judge. And that could play in as a factor here, that the judge was very quick on the gun to call mistrial rather than actually polling the jury and trying figuring out, okay, well, you say you can't reach a conclusion here. Which charges are you struggling with? Which charges have you reached a conclusion on? So the jury never had an actual opportunity to say what Karen Reed believes they would have said, which is not guilty on murder 2 and not guilty on fleeing the scene of a crime. And since they didn't say it, and you had a judge call mistrial without actually investigating whether or not they had reached conclusions on any of the charges, that leads Karen Reed to say that since they came to this unanimous conclusion that I was not guilty of murder 2, not guilty of fleeing the scene of a crime, that it is a violation of the Constitution for the state to come forward and try and accuse me of those crimes yet again when a jury has reached a unanimous decision acquitting me. It's an interesting theory, a very interesting theory. And what they're trying to say is that once the defendant has produced credible evidence of such a final, unanimous, and unannounced acquittal, if she can do that, at the very least, you should have to poll the jury. Have the jury brought in before the court from the last trial, have them brought into the court, and have them actually tell the court whether or not they did reach that unanimous decision and that the judge failed to actually do her job in actually asking them those questions, in which case, if in fact it turns out that Karen Reed's claims are correct, that they did unanimously agree to acquit her on these charges, on the charges 1 and 3, specifically murder 2 and fleeing the scene of the crime, in that case, the state can no longer charge her. Because right now, they're in the middle of jury selection. I believe they have 10 jurors so far, and they're in day 6. I think they might have gotten to 12 jurors today. I was a little confused based on a report I saw. They're looking to get 16 jurors. So they basically, shouldn't be going forward with this trial in the opinion of Karen Reed, because how can you go forward? It's double jeopardy. It's a reasonable ask to at least have the Supreme Court weigh in on this issue. I'll tell you that. Glasses are on bookshelf. Thank you so much. Just told jurors not to fill out any verdict slips until they're unanimously insured on all charges. AJ told her instead motions were unclear. All right. I don't know. All right, let's go forward here and see what it is that they bring up the related proceedings with these different cases of Reed versus Norfolk and all these different applications they had and cases that have been going forward. And then they go through the table, the questions presented. This thing is 149 pages, but there's only 25 pages of actual stuff for us to read through. So it's not that much of a bear, but it is good to go through it. No official citation. The opinion of the First Circuit Court of Appeals is yet available, but the opinion may be found in 2025 Westlaw 926289 from petition 1A 19A. The opinion of district court is unpublished but is available. And they didn't agree with us. The opinion of Massachusetts Supreme Judicial Court is reported at 495. That was at the lowest level. Massachusetts Superior Court's order denying Reed's motion to dismiss is not reported. Statement of jurisdiction was saying that you have jurisdiction. The judgment of the First Circuit was entered on March 27th. That's why you have jurisdiction. This circuit has jurisdiction to review the First Circuit on a writ of certiorari. Constitutional provisions, double jeopardy clause of the Fifth Amendment provides, nor shall any person be subject to the same offense to be twice put in jeopardy of life or limb. That's the language. That's the key language here. Nor shall any person be subject for the same offense to be twice put into jeopardy of life or limb. There you go. It's actually, we're going to make that color yellow because it's statement of law. Okay. That's your double jeopardy. This case is an ideal vehicle which to resolve an issue. Now, understand the objective here is they're trying to explain to the court why it is the court should pick this case up. So in their introduction, they want to say, hey, look, this is an important area of law that's very fresh. No one's really decided this before. The Supreme Court has never weighed in on this, and it's an important thing for the public and district attorneys to know as to whether or not, and for the court to know, lower courts, trial courts to know whether or not there's potential double jeopardy or jeopardy may attach, even if the jury is not polled. The case is an ideal vehicle to resolve an issue of fundamental constitutional importance argued to the court but not decided in Bluford versus Arkansas. Bluford versus Arkansas 566 US 599. So we like making these in blue when we see a citation. So there you go. So Bluford versus Arkansas, the petitioner in Bluford argued that where the jury actually resolved some elements of a charged offense in the defendant's favor, no formal verdict need be returned for that decision to constitute an acquittal prohibiting reprosecution under the double jeopardy clause. So this came up in Bluford. The petitioner said the same thing that we're saying, that once they resolve the issue, this was a claim that they made. So let's put this in green. It's not law, but the claim that they made was where the jury actually resolved some issue in their favor, no formal verdict need be returned. And it still would constitute as far as being double jeopardy. That's what they're saying. As soon as the jury reaches that unanimity on an issue, it's resolved. It's an interesting claim. It's an interesting claim. I have a lot of thoughts on this. I'll get to that as we go through these papers. If you have thoughts on it, please don't hesitate to share them with me because I'd be curious to know what you all think. I'm not going to kid you. Why is this not? Why am I not seeing? Why don't I see the chat here? That's weird. Trying to figure out why I can't see chat, and it should be playing in Rumble. It doesn't look like this. Why is it not playing in Rumble? Let me see something here. If I can see anything. Is there any Rumble chat here? Why don't I see Rumble chat? Should be playing in Rumble. He's in Rumble. Okay, well, I see Rumble. Trying to make sure I'm not missing any rants in Rumble. The struggle is real here. I'm not going to kid you. I missed yesterday at the very end of the show. Breck Nichols said, "Joe, you said you mostly eat grapefruit tomato soup. That sounds like a terrible soup." But I'm a little frustrated right now. I'm not going to kid you. Why don't I see it? Let me see if I click this. Oh, there you guys are. Okay. I was worried. I couldn't find you. I found you. All right, let's get back into where we are. The divided court did not decide that question because in Bluford, the majority concluded that the four-persons mid-deliberation report regarding the jury's votes lacked the finality necessary to amount to an acquittal. What they basically, this is actually a legal thing, so let's change that to yellow. So the court in Bluford never really answered this question because they never said what would happen if they did reach finality, that there was an actual finality from the jury. What they said was there wasn't an actual finality from the jury. It looked like sort of maybe it was some sort of finality, but they didn't have an actual finality. So the court never really addressed, well, what if they had reached finality but never answered, never had a chance to announce it to the courts? The judge never gave them that opportunity to announce it to the court. What would the law be when they had reached a finality? We understand that the court said that what happened in the Bluford situation was not finality, but what if it had been? Would that be jeopardy? Would that now require the court to say we can't go any further and have a retrial because there's been double jeopardy because there was finality by the jury? That's quite apart from any requirement that a final verdict be returned or judgment entered. It's almost, you can read it as implying if the jury had reached finality, that would be some sort of question of, then that could create a jeopardy situation whereby the jury would be, that finality of the jury, even though they don't announce it in open court, would still qualify to have jeopardy attached. The instant case squarely presents the question that Bluford did not decide. Here, beginning the day after petitioner's first trial ended in a mistrial, 4 jurors contacted trial counsel to inform them that the jury had reached a final and unanimous. Now, these are facts that they're claiming here, right? That there was there are 4 jurors came out and said that there was a final and unanimous but unannounced conclusion that petitioner Karen Read is not guilty of murder in the second degree and of leaving the second collision, which is 2 of the 3 charges pending against her. So this is what happened. Look, they never had a chance to come forward, but this is what they're saying happened here. That there are 4 jurors came to us and said, we had unanimity. There's no second degree murder here. We had unanimity that there was, she didn't leave that. The one thing we got hung up on was whether there was vehicular manslaughter, but we didn't get any, but we had unanimity on those 2. A statement by a 5th juror relayed indirectly to counsel via 2 intermediaries indicated the jury had agreed that Read is not guilty of the murder charge. In addition, one of the jurors made a similar representation to the prosecutor. The jury's not guilty verdicts were not announced because the trial court, believing but not confirming that the impasse reported in a series of 3 juror notes applied to all. She thought it applied to all of the charges rather than only some counts, never inquired regarding the scope of the deadlock. That's on the judge, and the jurors failed to volunteer to the trial court that their impasse was limited to 1 of the 3 counts rather than all 3. So there was just this miscommunication, which you could really blame the court for, that the judge should have asked them, hey, are you deadlocked on everything? The First Circuit held, even if we assume that the jury unanimously voted in private, that the prosecution had failed to prove its case on counts 1 and 3, the jury did not act on that view. So they never took any steps. This was a finding at the circuit court level that, hey, they never acted. Jury did not act on that view, and accordingly, there was no act here that could be considered a ruling or characterized as an acquittal. There's no act, since the jury in the first case never came forward and said anything, there's no act which we can say this is now an acquittal or a ruling. That holding runs contrary to this court's repeated emphasis over more than a century that what constitutes an acquittal for purposes of the Double Jeopardy Clause is controlled by substance, not form. Substance is what matters, not whether or not they had the form of coming out. As long as they reach that unanimous finality, the petitioners here are arguing that that would count for double jeopardy to attach. The First Circuit's related denial of a post-verdict voir dire further prevented Reed from proving from all 12 jurors what many of them, without any contradiction from the other jurors, were representing, that they had reached a final unanimous unconditional decision to find her guilty, not guilty of murder. So what are they really asking for here? The petitioners are saying, look, you don't want to trust us. We understand that. You're not going to say, well, her lawyers came forward and said there was a unanimous decision. What you should be doing, you should be mandating, is that there should be a voir dire, an inquiry, where each juror is called up to testify in front of the court and say and attest as to whether or not all 12 of them had unanimously agreed that she was to be found not guilty on the count of murder. She was to be found not guilty on the charge of fleeing the scene of the crime. And that's what the First Circuit, they're saying, should have ordered, because there was finality, but the court refused to order such a thing. Now, I will tell you something that we should think about in the context as we go further here is there is a strong perspective. There's a strong theme throughout the legal system that what happens behind closed doors in the jury room should never be inquired by anybody. The objective is that we want to keep them, when they're in the jury room and the future juries going into deliberation, that they should feel free to voice their opinions without fear that they're going to be questioned or interrogated about it. So as a general rule, we tend to say whatever happens in the jury room, it's like that happened in Vegas, it stays in Vegas. We don't want to know from it. We don't want to think from it. It's not important. It's not relevant. And that is the overarching theme which the petitioners are fighting an uphill battle against. So anyone who thinks that the Supreme Court is going to be eager to jump all over this and say, oh, yeah, let's have a voir dire and find out what happened in the jury room, is unfamiliar with that premise, which is, as a general rule, what happens in the jury room stays in the jury room, and courts tend to be really, really reluctant before they ever are willing to put any juror on the stand and start asking them what was discussed in that jury room. It's a real no-no. So the only reason, so that's what the petitioner, that's what Karen Reed here is going to have a problem with, trying to convince the court that this is a step that should happen. It's a rough go of it. It's a rough go of it. The only reason to really look into this is because you could sort of say this was a court failure. This was an error by the judge. The judge should have done all this rather than just calling mistrial and sending everyone home. Like, this failure is by the judiciary, and it's now potentially punishing Karen Reed for the mistake that was made by the judge. Now, the judge is not considered the state. So a mistake by the judge is less likely to it's less likely as a general rule to result in an acquittal, because that's the state. The court is considered independent, and it's not considered as if the state was depriving her of her rights. It's an error by the judge that, in theory, could have stripped her of an opportunity to say jeopardy has attached, and now I'm not guilty on charges 1 and 3. Now, let's bear in mind here, before we go any further, first thing I have to say is, please make sure, if you're enjoying this content, you like, share, and subscribe. It's very important. Feeds the algorithm. I know it doesn't do anything to harm you, and it really makes my day. So if you could do that, I would be most obliged. But the other thing I wanted to share with you is that when we are looking at this entire context here, even if Karen Reed wins, gets petition granted, goes before the Supreme Court and wins, she still has to face charge number 2, which is the vehicular manslaughter. So, because the jury was deadlocked on, and there's not even a claim, obviously, from the defendant that she shouldn't have to stand jury on that. So we are going to have that trial. The question is whether the trial is also going to include charges for number 1 and 3, the murder and fleeing the scene. On June 9, 2022, Reed was charged in 3 separate indictments for second-degree murder in violation of Massachusetts General Law 265, manslaughter while operating under the influence of alcohol in violation of 265. So you have second-degree murder. These are the charges that she was hit with here. You got the second-degree murder. You got manslaughter while operating under the influence, and leaving the scene of a collision. These are the 3 charges, resulting in a death in violation. It's leaving the scene and resulting in a death. It's not just like leaving the scene. It's leaving the scene resulting in a death, which presumably is a higher penalty. A jury trial began April 16, 2024 in Massachusetts Superior Court. The trial court declared a mistrial on July 1. So that's the facts as to what happened here. So that's July 1. On June 25th, 2024, the jury began deliberations. After receiving instructions from the trial court, the court instructed the jurors, quote, "You should continue deliberating until you have reached a final verdict on each charge." Each charge, not all charge, not each charges grouped, but each charge. It also noted that count 2 contained lesser included charges of involuntary manslaughter and motor vehicle homicide, which the jury should consider even if the Commonwealth failed to prove the greater charge of manslaughter while operating a vehicle under the influence of liquor. Later, in supplemental instructions to the jury, the court again described count 2 as encompassing 3 separate charges. On June 28th, the 4th day of deliberations, the jury sent the following note to the court. Quote, "I am writing to inform you on behalf of the jury that despite our exhaustive review of the evidence and our diligent consideration of all disputed evidence, we have not been able to reach a unanimous verdict." This was obviously written by a very educated person who was almost certainly the foreperson. You can tell from the language there. The court sent the jury back to continue deliberations. On July 1, the jury presented another note saying, "Despite our commitment to the duty entrusted we find ourselves deeply divided by fundamental differences in our opinions and state of mind. The divergence in our views are not rooted in a lack of understanding. We get what we're supposed to be doing here. We understand the job. We understand that. We're just completely, as an effort, but we have deeply held convictions that each of us carry, ultimately leading to a point where consensus is unattainable. We're never going to come to an agreement here. This is like, some are voting Trump and some are voting Kamala, and you're not going to get them to agree here. We recognize the weight of this admission and the implications it holds." So, there you go. Saying, we understand we're making you have a mistrial. Sorry about that, but we can't come to any sort of agreement here. Court gave a so-called Tui Rodriguez charge and sent the jury back to continue deliberations. Let's look at what a Tui Rodriguez charge is. They explain it here. Tui Rodriguez charge is a model instruction given when jurors report deadlock after due and thought deliberation that is designed to urge a jury to reach a verdict by giving more serious consideration to opposing points of view. So she tried. Later that day, jury sent yet another note. "Despite our rigorous efforts, we continue to find ourselves at an impasse. Our perspectives on the evidence are starkly divided. We don't agree on anything here with respect to this evidence. Some members of the jury firmly believe the evidence surpasses the burden of proof, establishing the elements of the charges beyond a reasonable doubt. Conversely, others find that the evidence fails to meet the standard and does not sufficiently establish the necessary elements of the charges. The deep division is not due to a lack of effort or diligence, but rather a sincere adherence to our individual principles and moral convictions." You can tell this is a highly educated individual. "To continue to deliberate would be futile and only serve to force us to compromise these deeply held beliefs." Like I said, highly educated individual here. Okay. Fine. That's what happened. After reading the notes on the record, the court, without any apparent consideration of alternatives, the judge didn't do anything, didn't ask us, hey, what do you want to do about this? Didn't poll us, didn't do anything. What did the court do? Such as asking whether the impasse, she didn't ask the jury whether the impasse was to all as opposed to just some court counts, and without first inviting counsel to be heard. They didn't call on us, say, hey, what do you want? Sua sponte, it's a Latin term meaning of its own initiative, declared a mistrial and dismissed the jury. Just sent them home. You just threw out 6 weeks worth of trial and just pissed it down the drain without even asking us to weigh in as to what we would like them to do, without asking the jury whether there was any sort of impasse. This is just the judge, this crazy judge. She decided, oh, look, they're an impasse, they're a mistrial. All right, mistrial. Go home. Pretty bad call by the judge. Pretty stupid call by the judge. That's really sloppy work. Really sloppy work. Let me make sure I didn't miss anything here. An alternate juror who is an attorney has joined Karen's defense team for second trial too. Judge is awful, in my opinion. I think her name is Victoria George, from my recollection. Yes. She's not sitting at the table, but they poll jurors all the time. This is true. It's similar to polling the jury after verdict. It does not cross line. Don't have to ask what others said, just what each one decided. No, but the point is, it's a pretty basic question saying, hey, did you reach anything on any of these counts? Like, why would you not ask that question? It's the ultimate brain fart there. It's an embarrassing brain fart by this judge. It's inexcusable brain fart. Like, how it is that she didn't go down that road is kind of, it's inexplicable. It's incredibly stupid. All right. Post-trial juror statements reveal that jury found Reed not guilty on counts 1 and 3. Next day, on July 2nd, unsolicited by any party, and we didn't go to them, but here's more facts for you, Supreme Court. Unsolicited by us, one of the jurors contacted one of the attorneys for Reed Allen Jackson. So Allen Jackson was reached by one of the jurors. Juror A stated that she wished to inform Attorney Jackson of the true results of the jury's deliberations. According to Juror A, the jury unanimously agreed that Karen Reed is not guilty of count 1. Juror A was emphatic that count 1, second-degree murder, was off the table, and that all 12 jurors were in agreement that she was not guilty of such crime. So we all came to the same conclusion. She didn't commit murder. Jury also unanimously agreed that Karen Reed is not guilty of count 3, leaving the scene with injury or death. So that's where this juror comes to us. Now, you might think she's a crackpot, she's a crazy, she's a lunatic, she's a Karen Reed fan or whatever, but you might think that. But one day later, on July 3rd, another attorney for Reed, David Yannetti, was contacted by 2 different individuals, hereinafter informant B and informant C, who had received information from 2 distinct jurors, both of whom were part of the deliberating jury in this case. Informant B sent attorney Yannetti, quote, a screenshot she had received from someone of text messages that intermediary B had received from juror B. In that screenshot, juror B texted the following to intermediary B, quote, it was not guilty on second degree and split in half for the second charge. I thought the prosecution didn't prove the case. No one thought she hit him on purpose or even thought she hit him on purpose. It was evident. Everyone knows she did not hit him on purpose. Maybe she did hit him, but everyone thought, no, she definitely didn't do it on purpose. Juror B later placed an unsolicited phone call to attorney Yannetti, confirming that the foregoing information, which had been publicly filed in an affidavit, was accurate. So it's sworn to. It's not just hearsay, but it's, a sworn to statement. Juror B clarified, however, it still could be a hearsay. It's Alex's court statement, even if it's under oath. Juror B clarified, however, that he or she meant to write, no one thought she hit him on purpose or even knew that she had hit him. Juror B further told Attorney Nettie she believed that every member of the jury, if asked, would confirm that the jury reached not guilty verdicts on indictments 1 and 3. So here we have a second person saying the same two charges. Informant C had been in contact with another individual, intermediary C, who's a co-worker, and they joined a Zoom meeting during which Juror C discussed the trial. Informant C sent Unetti the below screenshots of his or her text messages with intermediary C regarding Juror C and what they revealed. And intermediary C said no consideration for murder 2. Manslaughter started polling at 6-6, then ended deadlock. Informant C, interesting. If it was no consideration for number 2, shouldn't she have been acquitted on that count and hung on the remaining charges? Goes back to the jury verdict slip that was all confusing. Intermediary C says she should have been acquitted. I agree. Yes, the remaining charges were what they were hung on, and the instruction paper was very confusing. After the filing of Reed's initial motion to dismiss, but before a Superior Court hearing on that motion, Attorney Jackson was contacted by 2 other deliberating jurors. 2 more. The first, Juror D, stated that the jury reached not guilty verdicts on 1 and 3, and disagreement was solely on count 2 and lesser offenses. She recounted that after the jury was excused and aboard the bus, many of the jurors appeared uncomfortable with how things ended, wondering, is anyone going to know that we acquitted Karen Reed on count 1 and 3? Juror D unequivocally told counsel, every one of us will agree and acknowledge that we found Karen Reed not guilty of counts 1 and 3 because that's what happened. Juror E similarly stated that the jury was unanimous on 1 and 3 and Karen Reed was not guilty of those charges. Commonwealth filed a post-trial notice of disclosure informing the court that on Sunday, July 21st, the assistant DA received an unsolicited voicemail on his office phone line from an individual who identified themselves as juror by full name and seat number. The message stated, it is true that what has come out recently about the jury being unanimous on charges 1 and 3. The ADA received a subsequent message from the same individual saying that she couldn't confirm unanimous on charges 1 and 3 as not guilty, and as the last vote, 9-3 guilty on the manslaughter charges. So it was 9-3 on the manslaughter. So she wasn't doing well on the manslaughter, but she did very well on the murder and the other charge. Commonwealth additionally received emails from 3 individuals identifying themselves as jurors and indicated they wish to speak anonymously. Commonwealth declined to substantively respond to the voice messages or emails, instead claiming in response to emails that it was ethically prohibited from discussing such matters, which they could hide behind that because, like I said, there's this long-standing concept of we're not supposed to know what happened in that jury deliberation room, especially if it's not relevant. So, but the Supreme Court could decide it is relevant if, in fact, they say there would be finality if there was unanimity that was unannounced, and especially if that lack of announcement came via court error. We moved in the state trial court to dismiss. Arguing the jury's final unanimous decision reflected in the post-trial affidavits that she's not guilty in these charges. Trial court denied Reed's motion. Court accepted the jurors' statements reflecting the affidavits as true and accurate, as did each other court that reviewed the legal issues. So no one's arguing that what we're telling you here is true. There's no claim about an inaccuracy that we're misstating the facts. It's a legal question. What's the law in this scenario? Because there was no open and public verdict affirmed in open court rendered this case, the defendant was not acquitted of any of the charges. That's what they held, these lower courts. The court also held that Reed was not entitled to a post-verdict inquiry because her argument did not implicate racial bias or her right to receive an impartial trial, and because her request would necessarily require inquiry into the back and forth among the jurors during deliberations. As I told you, they don't like that. They don't like, as a general rule, that is what they don't like them doing. They want to keep that sacrosanct. So I'm not surprised that a lower court said we don't have a right to do this. And I don't think that's necessarily a wrong ruling on this part. Even if Karen Reed, even if you love Karen Reed and you think she's being railroaded, the duty of the court is to follow the law. There is as I said before, there's a long-standing understanding that the court is very limited in circumstances where they have jurisdiction, permission, authority to inquire at all what happened in the deliberation room. It's supposed to be sacrosanct. Now, there are exceptions to that, but those exceptions are via statutes. And if the statute doesn't say that they have a right to inquire about it for the purpose of assessing whether or not jeopardy attached and a retrial would be double jeopardy, then the court decided correctly because they're following the statute. Even if we don't like the outcome, even those of you who are big Karen Reed fans and may hate the outcome, the reality is if that's what the statute says, they're following what the law says. The only question is whether that law, whether restricting them from doing that assessment is considered a constitutional violation, and that every court in the country should allow for this sort of inquiry. Frankly, I think the Supreme Court may be very hesitant about starting to go down this road. I think they might be very hesitant about it. Repetition the Massachusetts Supreme Judicial Court pursuant to Massachusetts General Laws 211. Single justice referred the petition to the full court. COA joined Act 470. The Supreme Judicial Court ultimately affirmed the denial of Reed's motion to dismiss, concluding, like the trial court had, that because the jury did not publicly affirm a defendant was not guilty of the charges, there was no acquittal, barring retrial under the Double Jeopardy Clause. Additionally, holding the trial judge did not err or abuse his discretion in denying Reed's request for a post-trial inquiry, where it would not change the outcome of the defendant's first trial. Because there's nothing in the likely, almost assuredly, I'd be surprised if they were wrong about this, almost assuredly. There's no statute, which implies that there is an opening to start inquiring into jury deliberations in this type of scenario. The jury chose to report a deadlock, not a verdict, and no basis exists for further investigation into private discussions or subjective beliefs they declined to announce publicly in open court. Reed subsequently filed a federal petition for writ of habeas corpus in federal district court, again contending, inter alia, which means is Latin for amongst other things, that the jury's conclusion that she's not guilty constitute an acquittal, and that she's entitled to post-verdict inquiry on that issue. So their conclusion, this is her claim now, this is not law, this is just a claim. So her claim is, I'll put this in right because it's a claim as opposed to facts. So her claim is that she's not guilty and that because that she was entitled to a post-verdict inquiry on that issue. The district court denied her petition and Reed appealed to the First Circuit. The First Circuit affirmed. They began from the premise, long established in court's case law, that in deciding whether the defendant was acquitted, court must focus on substance over labels and look to whether the ruling substance relates to the ultimate question of guilt or innocence. Despite the fact that the Bluford court expressly declined to find that lack of a formal verdict was dispositive regarding double jeopardy implications of a jury finding, the First Circuit found Bluford was dispositive. So what they're saying is your First Circuit's relying on Bluford, but Bluford is very different from our case here. Bluford, there was no finality there. The First Circuit stated that the post-trial juror statements here were far weaker than the four-persons mid-deliberation statement in Bluford, because the statement here did not describe when any votes were taken or whether such votes were preliminary or formal. So what the First Circuit was saying when they decide against us, when this is a ruling from the First Circuit, so I'll put this in yellow, they said that what happened in Bluford was there was at least some sort of vote or something like that happened mid-deliberation. Here, there's no basis to assume that there was a vote that was anything but a preliminary, what are your thoughts, as opposed to how do you vote on count one. And if there's no how did you vote on count one, even if they're all talking for the entire time, unless they have an official vote on count one or on count three, the First Circuit is saying it's not even as good as Bluford, and Bluford tells us there's no finality to it. You need to have some sort of finality. even though I assume the First Circuit is crazy woke, this logic behind this. It's a reasonable read. It's a reasonable read of what statute and case law says. Like Bluford, there's no sign that a final vote was taken, meaning that if any deliberations continued after a vote, jurors could have changed their minds. They might have said she's guilty on murder. They might have said she's guilty leaving the scene. Nor did the jury announce its verdict in open court. Ultimately, the First Circuit concluded, even if we assume that the jury unanimously voted in private, that the prosecution had failed to prove its case on counts 1 and 3, the jury did not act on that view. And there was simply no act here that can be considered a ruling or characterized an acquittal. So that's really getting into form over substance. First Circuit also concluded that the post-trial hearing requested by Reed would not be appropriate because the content of jury deliberations is typically kept secret to enable jurors to discuss the views freely and frankly and to protect them from harassment. That's a recognition that every jurisdiction in the nation has. Now we're facing re-prosecution, starting with jury selection on April 1, 2025 by the same prosecutor for the same offenses, murder, leaving the scene, despite powerful evidence the jury in her prior trial found her not guilty. Reasons why this writ should be granted. Before I go further, so now you all have the bare bones. You have a basic understanding as to like what's happening here, what the arguments, what the background is, what the arguments are being made, a little bit of understanding as to how the courts tend to look at jury decisions. Do you think that this is something the Supreme Court should take up and overturn? The judge is very connected to many witnesses. Her brother represented in fatal DUI, the brother of a cop whose lawn John's body was found on. So you're saying she was trying to avoid hearing the jury say not guilty on murder too? Could be, but it's hard to prove that.
Fuck out, because tell me why.
So I'm going to put a quick poll up here, ask you, should SCOTUS take this up? Should SCOTUS take this petition? Charges because of double jeopardy. Take up dismiss charges. Take it up and dismiss charges, reject the application, or take it up and tell Reed you lose. Those are your three options right there. The First Circuit's ruling conflicts with this court's double jeopardy case law, including its consistent emphasis on substance over form and determining what constitutes an acquittal. As this court recently reaffirmed, the ancient right to a jury trial is no mere procedural formality, but rather a fundamental reservation of power to the American people. Requiring the executive branch to prove its charges to a unanimous jury beyond reasonable doubt, the Fifth and Sixth Amendments seek to mitigate the risk of prosecutorial overreach and misconduct. Prominent among the reasons Colonists cited the declaration for their break with Great Britain was the fact that Parliament and Crown had deprived them in many cases of the benefits of trial by jury, and after securing their independence, founding generations sought to ensure that what happened before would never happen again. As John Adams put it, the founders saw representative government and trial by jury as the heart and lungs of liberty. That's what freedom's all about. It follows that a jury acquittal is entitled to the utmost respect in our criminal justice system. The jury's overriding responsibility is to stand between the accused and a potential arbitrary or abusive government that is in command of the criminal sanction. Jury is a necessary check to government power. None of this is really helping you. These are all nice statements, true, but it's not really helping here, I don't think. One of the central benefits, but it's the sort of fluff that attorneys tend to write, so I'm not critiquing them for putting it in there, but one of the central benefits of a right to a trial before an impartial jury is that if the jury acquits, the sovereign cannot re-prosecute. Double Jeopardy clause provides no person shall be subject for the same offense to be twice put in jeopardy of life or limb. Citing Bluford v. Arkansas, the underlying idea, one that is deeply ingrained in at least the Anglo-American, now this could be helpful, because now we're getting into, this is on point, and this is a citation from Bluford. The underlying idea, one that is deeply ingrained, at least the Anglo-American system of jurisprudence, is that the state, with all its resources and power, should not be allowed to make repeated attempts to convict an individual for an alleged offense, thereby subjecting her to embarrassment, expense, and ordeal, and compelling her to live in a continuing state of anxiety and insecurity, as well as enhancing the possibility that even though innocent, she will be found guilty. No double bites at the apple. And that was citing Green versus the United States. What constitutes an acquittal is not to be controlled by the form of the action in question. And this is what they're trying to say. This is the key element here that they're trying to hang their hat on. It's not about the form that they came forward in open court. It's that they reached this decision. They reached this decision. Rather, the court must determine whether the action actually represents a resolution, correct or not, of some or all of the factual elements of the offense charged. Labels, including those provided by state law, do not control the analysis. Here, affidavits by attorneys Jackson and Yannetti reflect post-trial statements by four deliberating jurors, but the jury had reached a final unanimous conclusion that Reed is not guilty of counts 1 and 3, and an indirect statement by a fifth that they agreed with respect to count 1. A call by one juror to the prosecutor himself corroborating the trustworthiness of these representations. So it's not us lying to you. We're not sitting here trying to deceive the courts. Neither the Commonwealth nor respondents ever challenged the authenticity or accuracy of the jurors' statements. Everyone's on board here that this is what the jurors are saying. Nothing tentative about their statements. I think it's to review what the different messages were that we went through. The First Circuit's rejection of Reed's claim of acquittal is rooted in formalism. Not really. Not really. One of the claims by the First Circuit is rooted in formalism. So this is argument. This is not really a statement. This is because by your admission, they said, look, there really wasn't any more finality here than there was in Bluford. And even if there was, still they didn't act on it. Even if it was, is the formalism that's been consistently rejected by the court. And that's the also. So you're really attacking the also, but you're never really attacking the first part, which is that they're saying that there was no formal vote. There may have been a preliminary thought, but they might change their minds over the next 5 days. This emphasis of substance over form applies in the context of both jury acquittals and judicial acquittals. This court has, for example, consistently refused to rule that jeopardy for an offense continues This is a ruling from the court. So this court has consistently held that jeopardy for an offense continues. They refuse to say that it continues after acquittal, whether that acquittal is expressed or implied by conviction on a lesser included offense. We believe this case where the defendant was charged with first and second degree murder and the jury returned a verdict finding him guilty of lesser offense can be treated no differently for purposes of former jeopardy than if the jury returned a verdict which expressly read, we find defendant not guilty. So you can see an implication there from the jury saying we only find him guilty on the lesser offense, that they're finding him not guilty on the greater offense. That's what the Supreme Court has said in the past. The acquittal here was the jury's unanimous and final decision, reflecting in this post-trial affidavits that Reed is not guilty. The court has instructed that an acquittal has occurred if the fact finder acted on its view that the prosecution has failed to prove its case. Here's a key word here, though, that I think that they're going to struggle with. There's a key word here that I think they may struggle with. And that is this word right here. Yeah. This word right here. Acted. Did the jury act on it? The jury is the fact finder here. This is where you're going to struggle if you're Karen Reed. Because the court has instructed that acquittal has occurred if the fact finder acted on its view that the prosecution has failed to prove its case. Did they really act on it? How did they act on it? Acting on it by notifying the lawyers after the fact is not generally considered acting on it. So I don't know that the cases that they're citing from the Supreme Court are going to help Karen Reed. It's tragic because I do think that she's being screwed here. I think she's being screwed here. I just don't think you have that the case law that I've read so far is strong enough to actually get her this petition granted and an acquittal on charges 1 and 3. Even though I think she probably was found not guilty by them, by a unanimous jury. But it was a failure really by everyone involved. I mean, the lawyers could have jumped up. Her lawyers could have jumped up and said, hey, let's poll them on counts number 1 and 3. If they're deadlocked, maybe they've already found not guilty on one of the charges. That's a way to, that's something I think it's a failure. It's a failure by everyone involved. Not going to kid you. That's the court first and foremost. The defense to say, hey, if they're deadlocked, obviously they must be leaning, and they're not even like splitting the baby and finding her guilty on the lower charge. It must be, chances are pretty high they're not finding her guilty on the first charge. We should try and get that stated on the record. So I think that's a failure by defense counsel, and the prosecution too should have, in fairness, should have reminded the court. I think this is a failing by everyone involved. And the jury themselves, they could have come forward and said, hey, we found her not guilty on some of these charges. I think everyone involved here kind of dropped the ball. Now her defense counsel is trying to fix it up. It's not dispositive whether a fact, and I'm not, look, it's a long trial. I'm not saying it's malpractice or anything like that. I'm simply saying there's a lot of reasons why things could have gone awry, but it was clearly the wrong call. Is human error. First and foremost, this is on the judge, though. This court also said it's not dispositive. Yikes, didn't do that. Saying it's not dispositive whether a fact finder encountered the word acquit. Justice Sotomayor, joined by Justices Ginsburg and Kagan in dissent in Bluford, reaffirmed that in ascertaining whether an acquittal has occurred, form is not to be exalted over substance. So it's always good to try and invoke the name of certain justices who are still sitting on the bench, like Kagan and Sotomayor, saying, hey, it's not about the form. Rather, the court asked whether the fact finder has made a substantive determination that the prosecution has failed to carry its burden. Jeopardy terminates upon a determination, however characterized, Doesn't matter whether it's a formal statement in court or it's something that happened behind closed doors, what they want to say, that the evidence is insufficient to prove a defendant's factual guilt. Justice Sotomayor defined a verdict in its substance as a final collective decision. A final collective decision reached after full deliberation, consideration, and compromise among the individual jurors. Consistent with these principles, it is not unprecedented for a jury's unanimous and final decision to supersede even verdict slips that fail to accurately reflect such collective juror decisions. So it doesn't matter we care about what happened in writing, the form of it. We just care, did they reach a decision or not? Reed cited 2 cases in which a jury's unrecorded vote for acquittal was given effect, notwithstanding the jury's failure to formally announce such verdict. We had U.S. versus Dotson, where they affirmed correction of verdict on 1 count after receiving a telephone call from 2 of the jurors, stating that contrary to the verdict read in court, jury had unanimously voted to acquit. It was vacated in part on other grounds. And also you had the Stauffer case. So in Stauffer, they affirmed changing verdict on a count where post-verdict interviews of several jurors determined that the jury had intended to acquit, and they said stupidly guilty. The Bluford majority opinion is not to the contrary. There, the foreperson had reported during deliberations that the jury was unanimous against the charges of capital murder. So that's what the juror had said. Hey, we were unanimous against, and we're unanimous in acquittal on capital murder and first-degree murder, but split on lesser included charge of manslaughter. The court sent the jury back to continue deliberations, and when the jury remained unable to reach a verdict, declared a mistrial. The court rejected the defendant's argument that double jeopardy clause prohibited re-prosecution for capital and first-degree murder. In doing so, the court relied heavily upon the lack of finality in the juror's report. The jurors' deliberations had not yet concluded, so they basically had taken the capital punishment issue, and they said, well, maybe they went back to the capital punishment issue later on. Maybe when they went back to deliberate further. Foreperson's report was not a final resolution of anything, and there was no indication in the conclusion of deliberations that it was still the case that all 12 jurors believed that defendant was not guilty of capital first-degree murder. So that foreperson's mid-deliberation report doesn't have finality that's necessary to be acquitted, quite apart from any requirement that a formal verdict be returned or judgment expressed or judgment entered. Additionally, in Bluford, the jury was deliberating on lesser included offenses within a single charge, such that under Arkansas law, the jury's opinions were limited to 2, either convict on one of the offenses or acquit on all. But Massachusetts, it says you can have a partial verdict on separate indictments. So perhaps that changes things here. First Circuit erred in finding Bluford dispositive here. Unlike the foreperson statement of Bluford, the affidavits reflecting juror statements in this case were all executed post-trial. So when they're filling this out, that's all post-trial. The fact that now you're trying to rely on the affidavits. This is not anything that was done in the trial. This is these affidavits which happened after mistrial was declared. The fact that in this context, the affidavits did not so much as hint that the decision to acquit was not final or revisited in any time in the powerful indicator is a powerful indicator of finality. Jurors' references to result deliberations and to not guilty verdicts reinforce that conclusion. Unlike in Bluford, the jury's decision was communicated after the conclusion of deliberations, such that there was no possibility that it was reconsidered. In these circumstances, First Circuit's conclusion that even if Reed's jury unanimously voted in private that the prosecutions had failed to prove its case on counts 1 and 3, there would still be no acquittal for double jeopardy purposes. Okay, I'm going to tell you where I'm at here, where I'm at right now. Where I'm at right now is I disagree with the First Circuit on this part. I think if they had a vote at the end there, I think that wouldn't matter under Bluford. Although the fact that they have to act, but I don't think, unless we know that they had some sort of vote on counts 1 and 3 at the end, I don't think she's getting her petition here. I don't think it's being granted. I'm not saying that's what the law should be. I'm just telling you that's, to me, how the law reads. That's what the law is. That you need to have that finality at the end there. There had to have been some sort of vote there. How do we find on count 1? How do we find on count 2? And then the mix it. How do we find on count 3? And then say, okay, we have unanimity on 1 and 3, but we're never getting anywhere on count 2. That's like your annual deliberations. That's what they really are needing here. That's what they're really needing. But still no petitions that exalts form over substance in a manner contrary to this court's precedents, and Reed contends violates core principles of double jeopardy that prohibit the prohibition on successive trials. First Circuit's ruling that Reed was not entitled to post-trial inquiry to substantiate the facts of the acquittal is inconsistent with case law. So I'll tell you right now, I struggle with Karen Reed's claim here, because I don't think that there's evidence of finality. I don't think you can introduce the affidavits that happened after the fact as proof of something subsequent to, because they're dismissed. Once they're dismissed, everything is done. You can't fix it. It's not, the plate's shattered. You can't fix that afterwards with an affidavit. That's my personal take. I'm not saying it's what the law should be. I'm just telling you that's my personal take as to what the law is on this. I don't think the court's going to give them that. But let's hear their argument to say that there should be a voir dire. The post-trial inquiry to substantiate the fact that the acquittals is inconsistent with this court's case law. First Circuit also relatedly affirmed the district court's conclusion that even assuming the post-trial voir dire elicited evidence strongly favorable to petitioner, such as an attestation from each juror, the jury voted unanimously to acquit petitioner on counts 1 and 3 before being discharged, her claim would still fail. So this is an interesting thing. And maybe the First Circuit put this in there because they didn't want to start going through this whole voir dire situation. But let's imagine we had a voir dire, and in the voir dire, all 12 jurors came forward and said, "Oh yeah, right before we sent that last note to the judge, we had a vote, and the vote was acquit on number 1, acquit on number 3, and mixed on number 2." So maybe that I would think that should have some sort of impact here. Still have that issue as to whether or not they acted, because it does seem like you need to have an act. Where was it? Yeah, that you have to have this court instructing acquittals occurred in the fact finder acted on its view. I guess perhaps that vote would be counted as an act in theory. Under this reasoning, sworn and credible statements by all 12 jurors attesting to a final unanimous decision to acquit would not be sufficient to mount a successful double jeopardy challenge. The result is not required by logic or precedent and is inconsistent with this court's precedents arising from other contexts. Additionally, First Circuit cited concerns about maintaining the secrecy of jury deliberations and denying the request for post-trial voir dire. And I understand I understand how they think it's that secrecy. And secrecy here is a big deal because you want them to feel free. In the analogous context of juror bias, the law is clear that defendant's Sixth Amendment right to an impartial jury also guarantees the opportunity to prove a claim of bias. Okay. Meaning, let's say some of the people in there were like, "Ain't no way I'm going to free that Jew Reed." Like that would be something that you could actually voir dire them on. Post-verdict inquiry is similarly required. I don't know if she's Jewish or not, by the way. Post-verdict inquiry is similarly required to investigate claims of external influence. In Remmer v. U.S., After the jury had returned its verdict, the petitioner learned for the first time that during the trial, a person unnamed had communicated with a certain juror who afterwards became the jury foreman and remarked to him that he could profit by bringing in a verdict favorable to the petitioner. Ooh, bias. Verdict favor. A little bribery going on here. A little bit of bribery going on. Trial court, without defense knowledge, then enlisted the FBI to investigate. Court held that the defendant was entitled to a post-verdict inquiry regarding the FBI's unauthorized contact with jurors. Reed submits that there's no legal or constitutional basis to afford less rights to a defendant seeking the ultimate benefit of her right to a jury trial, an acquittal, as found by a unanimous jury by her peers, and those regularly granted to defendants raising process-related challenges that contend the jury was biased. A good faith Fifth Amendment double jeopardy claim, where Reed has met her burden of production, should be entitled to no less procedural protections as a good faith claim of a juror has, of juror bias. Reed acknowledges there's little precedent involving situations factually similar. I got to work with an analogy here because, frankly, we've never seen ever before a jury being polled about whether or not they had found for an acquittal. So that's why I'm going to this whole analogy about juror bias. This case is unique. It's not often that after trial, one juror, much less four jurors, directly contact defense counsel stating in no uncertain terms that the jury had acquitted. But the unique strength of the evidence underlying Reed's motion to dismiss clearly demonstrates that she has met her burden of production and fully supports rather than undermines her claim for relief. Ordering a post-trial voir dire would answer the First Circuit's concerns that she's not guilty. Terminations. You didn't get a poll? You say, where's the poll? Poll didn't go up? Oh. I don't know why that happened. I'm sorry. Thank you. Thank you, Nona. I don't know what happened there. I thought it went up. I do need my glasses. They're all mocking my vision. I knew this was going to happen, honey. She is asleep. She is asleep. Where are my glasses? Oh, gosh. Thank you, Nana. I even read your name as Nona. Oh, God. I'm so bad. I'm so bad. Ordering a post-trial voir dire would answer the First Circuit's concern that not guilty determinations were not final. So maybe we'll find out. Maybe it was final, maybe it wasn't. The simple outline of 2241 makes clear that Congress envisioned habeas petitioners would have some opportunity to present and rebut facts. In fact, this court has held that a federal habeas court must grant an evidentiary hearing, whereas here the merits of the factual dispute were not resolved in the state hearing. Ooh, there you go. If the merits of it were not resolved in the state hearing, you got to have an evidentiary hearing. This is necessary corollary of a straightforward proposition that where specific allegations before the habeas court show reason to believe petitioner may, in fact, if the facts are fully developed, be able to demonstrate that she is in custody illegally and is therefore entitled to relief. It is a duty of the court to provide the necessary facilities and procedures for an adequate inquiry. So, in general, what they're trying to say is there's a concept that if we can't find out the facts, the court has to provide with an opportunity to investigate further by having this evidentiary hearing. It is typical, not the rare, case in which constitutional claims turn upon the resolution of contested factual issues. Thus, a narrow view of the hearing power would totally subvert Congress's specific aim of affording state prisoners a forum in the federal courts for the termination of claims of detention in violation of the Constitution. First Circuit was also wrong to deny the request for post-trial hearing to maintain confidentiality of the content of jury deliberations. The result of jury deliberations are not secret. This was a result. So all you need to ask about was, did you have a vote? How did that vote come out? They are, in fact, routinely announced in open courts. So you don't have to ask them, what did you say about this? What did you say about that? The whole idea could be 3 questions. Did you have a vote at the end? The inquiry requested by Reed could be accomplished by a single or almost a small number of yes/no questions posed to jurors. Did you unanimously acquit Karen Reed of the charge? This is the questions they want them to ask at this hearing. Did you unanimously acquit Karen Reed of the charges in counts 1 and 3? Was your decision, or did you believe your decision to be final as to each count? Or similar questions that do not intrude into the heart of jury deliberations. That's true. Could be relatively simple. If all 12 jurors answer those questions affirmatively, no speculation regarding the basis of that unanimous conclusion could alter its constitutional significance. We simply cannot know why the jury in this case sided as it did, and the Double Jeopardy clause forbids us to guess. Prior to the enactment of the Federal Rule of Evidence, 606B, which the parties agreed was facially inapplicable here, court held that the rule against jurors impeaching their verdicts applied only in a proceeding actually impeaching that verdict, which indisputably does not describe this case, in which readers attempted to prove that the jury reached a verdict. Meaning, there's under the Federal Rule of Evidence 606B, jury that is saying that jurors can't impeach their verdicts. That's only if there was a verdict to be impeached. So that can't be a problem. And this court has held that at least in some circumstances, inquiry is required, even when it violates Rule 606B. In some, the defense learned post-trial, the jury reached a verdict that was not announced. It was at least entitled to the opportunity to substantiate that fact. Let us look at this situation here. At least let us substantiate that fact in order to ensure Reed is not unconstitutionally forced to stand trial for criminal offenses, including murder, of which he has already been acquitted. Such inquiry in no way intrudes on the deliberative process of the jury. Such an inquiry instead honors the jury's service, which a trial court described as extraordinary, rather than rendering irrelevant the efforts of at least 4 jurors to disclose that there was not an impasse on all 3 counts, as contrasted to only 1 count. Let's give some validity to their findings. Reed contends the Double Jeopardy clause guarantees against successive prosecutions and no less fundamental than the Sixth Amendment right to an impartial jury, and no less deserving of protection, including whereas here a defendant makes a persuasive and credible showing of an unannounced acquittal by post-trial hearing to substantiate and such acquittal. For all foregoing reasons, this court should grant Reed's petition for writ of certiorari. I like the second argument. I like the last argument better than the earlier one. I think analogizing, but you're going out on a really, really thin limb when you're asking them to create something new. And that's what essentially they're asking the court here to do. They're asking the court to invent something new, which is the concept of their having a voir dire, the purposes of establishing whether or not there was a vote at the end on counts 1 and 3. And that vote came out unanimous. So my gut is, I'll tell you right now, and I'm pretty safe terrain to say in general, only 3% of cases of petitions to the court actually are granted. Statistically, they're in a weak position here. I don't think it's going to be granted here. And I also don't think that the First Circuit really erred, at least on that first issue. At least on that first issue, which is saying, hey, look, and I think you can read Bluford to basically saying they have to act. Even if they did do it, they have to act. If there's no act, I don't think it's going to be granted. I'll tell you right now. That's my God. I could be wrong. I don't think it's a big Branson. For old people, glasses chained to wear on your neck. No. Joe said, let us see. Irony. Big font. Okay. Oh, look at this generosity from J.H. Schwalbach. You can't come to any verdict on guilt without knowing her stance on late-term abortion or transgenders in sport. The court is a mockery. That's pretty funny. It's not the way it's supposed to be. It's not supposed to be that way. It's not supposed to be that way. So what we have here, my friends, is a petition that even if they're successful, we're still going to have the trial. The trial's still going to be just as long, because even if the court was granting everything they wanted, at best they get a delay in the trial. At best, and they would have an evidentiary hearing, and then they would need first they need to get accepted by the court. Then the court would theoretically have to put a delay on this trial, which I don't think they want to do. I don't think they're very inclined to do it. They could say that we don't have to have a delay on it. Maybe have a one-day evidentiary hearing in the middle of the trial. Let the trial proceed and have a one-day evidentiary hearing where you call in all the jurors and say, hey, this ongoing Karen Reed trial, is it for all 3 counts, or did we knock out 2 of them? Then you would need all 12 of them to basically come in there and say that they had a final vote at the end, which does nothing indicate there was a final vote at the end. The way those affidavits read to me is they all agreed from the get-go, all right, she's definitely innocent on 1 and 3, and then they spent the next several days debating about number 2. They probably almost certainly never came back to numbers 1 and 3, because that's not the way normal people act, and they sound like pretty normal people. So they almost certainly did not have a final vote, and you would need all 12 of them to come in there and say, oh yeah, we had a final vote right before we send that last note. Which, why would they be doing that when they already all feel like they know how they're going to be weighing in then, and they don't know that they're going to get a mistrial without coming in there before the courts? So why would they have had such a final vote on counts 1 and 3? It seems unlikely it happened. So I think this is a bit of a Hail Mary, and I don't think that she's going to get out of it. Even though justice says she should if she was acquitted, but this is a screw up by the court, and unfortunately, I think Karen Reed is the victim of that. That's my take. It sucks, but that's based on the law. I don't think that she can get the relief she's seeking. Based on the law and precedent, I don't think she can get the relief she's seeking. And I don't think the court is going to invent a new type of voir dire here in this scenario, analogizing it to a Sixth Amendment issue of jury bias. I just don't see it happening. And even if it did, I don't see that the facts probably played out where there was a final vote at the end. That seems almost impossible that actually happened. It's more of a wish that her attorneys have. And the most likely scenario is they came out of it and started deliberations. They're like, oh, she's definitely not guilty of number 1, which I guess means she's definitely not guilty of number 3, because she didn't intentionally leave him there. If anything, she was reckless. So she probably didn't realize that she had him. Anyhow, that's probably what they came to, and they almost certainly didn't have a vote at the end. And without that vote at the end, Karen Reed can't. The law prohibits Karen Reed from being able to claim that jeopardy attached. Agree with the law, disagree with the law, but that's just the reality as to how the law reads. Let me see how my poll reads. Wow, 68% of you saying take it up and dismiss. 23% reject the application. 8% saying take it up until you lose. All right. Those are our numbers. And that's my show. I hope you enjoyed it. Please make sure you like, share, subscribe. Check out goodlogic.locals.com for more content from yours truly. Karen Reed trial is coming soon. When they actually get to opening arguments, I do tend to stream the heck out of this. Stream the heck out of this trial. So put Karen Reed out there for everyone. There you go. Karen Reed trial. You'll find it right here. And when I'm streaming it, you'll find that at goodlogic.locals.com. That's what I got. Lab meat is for they, them. It's not for you. Don't eat the bugs. Good night and Godspeed.